Powers of appointment, from snoozy to sexy. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Karen Gerstner, ACTEC Fellow from Houston, Texas. Recent times have seen resurgent interest in powers of appointment. We use them to keep long-term dynastic trusts evergreen, to be responsive to changing family, tax, and economic landscapes, and to transform old, tired assets into assets with new, exciting income tax basis. To learn more about this topic, you will be hearing today from ACTEC Fellows Tammy Canetta of Sarasota, Florida, and Neil Kawashima of Chicago. Welcome, Neil and Tammy.
Thank you, Karen. Credit shelter trusts and lifetime gift trusts have always been good planning techniques to take advantage of the applicable exclusion amount at the oldest generation. These trusts are designed to avoid estate tax inclusion, often for multiple generations. But with the current estate tax exclusion amount over $11 million, many beneficiaries in successive generations will not have a taxable estate at their death. This creates an opportunity to leverage their unused exemption amount. Estate planning professionals are looking at older trusts to find these opportunities to create estate tax inclusion that can address both income and transfer tax issues. For example, a trust with significant low basis assets could get a stepped-up basis at the current beneficiary's death if the assets are in their taxable estate. Or the beneficiary's generation skipping tax exemption could be applied to a trust that is currently not exempt to avoid a taxable termination. If structured carefully, these benefits can be realized without generating any tax consequences. Of course, the simplest path to estate tax inclusion is to distribute the trust assets outright to the beneficiary, but that option is not always the best option. Once in the hands of the beneficiary, those assets become subject to the claims of their creditors, could be lost in a divorce, or could simply be spent away. In either event, the intended remainder beneficiaries will not be happy. Neil, is there another option for us to consider?
Yes, there is. A better alternative is to create a general power of appointment in the beneficiary. For existing trusts, it may be necessary to decant the trust into another trust, or seek a judicial or non-judicial modification to add the general power of appointment. When drafting new trusts, you should consider whether to include an optional general power of appointment. And by optional, I mean a general power that is triggered or turned on either by some defined event or person. An optional general power of appointment can be defined by a fairly straightforward formula. The power to appoint a portion of the trust assets that doesn't exceed the power holder's available estate tax exclusion amount when combined with his other taxable assets or his available generation skipping tax exemption amount, for example. Or you can take a wait-and-see approach and name a trust protector who can grant a general power to a beneficiary when the circumstances are appropriate. Tammy, what are some considerations you have when adding a general power of appointment?
Well, Neil, for me, the first consideration is to have a clear understanding of the family dynamics. You don't want to add a general power of appointment to accomplish some tax benefit, only to have the power exercised in a way that disrupts the entire estate plan.
Couldn't you prevent that from happening by requiring a third party to approve how it is being exercised?
Yes, you can include a provision requiring a disinterested third person to consent to the exercise for it to be effective. A trust protector is always a good option for that. The trustee, on the other hand, is not a good option because their fiduciary duties to the remainder beneficiaries would make it almost impossible to gain their consent, and then the power could be deemed illusory by the IRS.
Tammy, what if you limit the general power of appointment to creditors of the power holder's estate?
Well, that can definitely narrow the potential appointees and lower the risk of an unintended exercise. And it is sufficient to create a general power for tax purposes, but I'm not convinced that it avoids the problem completely. If I'm the power holder and I want to get the assets to someone other than a presumptive remainder beneficiary, Couldn't I make that person my creditor, perhaps give them a promissory note payable at my death? I would also be concerned that in some states, just having a general power exercisable in favor of the creditors of my state may give those creditors a demand right on the assets subject to the power. The second consideration I have is when and how to turn on the general power of appointment. Neil, how do you think about flipping that switch?
If you use a straight formula provision in the document, then you don't have to worry about the springing aspects. But if you want to have more flexibility, then giving a trust protector the ability to turn it on or off is a good option. You just need to be careful that the trust protector is not a potential beneficiary. You also do not want to put the trustee in the position of turning the general power on for the same reasons you don't want to have them consent. The trustee is unlikely to take an action that could be detrimental to the interests of the other beneficiaries.
Neil, I really like the flexibility of having a trust protector who can add or remove a general power. It lets them consider other possible implications beyond just a stepped-up basis or a GST allocation. Depending on market conditions, the intended step-up could even be more of a step-down. And a formula provision could limit exercise to just assets that have a capital gain, but it does seem easier to have the ability to simply turn the power off in that instance.
It might be easier, but there is always the risk that the trust protector doesn't remember to turn it on or off. That assumes the trust protector knows she has that power. So the starting point is letting the protector know of her role. Then there needs to be close coordination with the trustee, the trust protector, the attorney, and the beneficiary so that all relevant factors are taken into consideration and monitored, such as changes in the federal tax laws and the impact of state tax laws. The attorney should somehow flag this to all parties so that there is less chance this will be overlooked. In addition to these practicalities, changes in law obviously could have a big impact on this type of planning. For instance, if the current estate tax exemption falls back to $5 million in 2026, as it is scheduled to do, flexibility will be critical.
That's very true, Neil. Causing estate tax inclusion seems pretty straightforward, but you really need to be alert to the risks that come with relying on people to do the right thing and changes in the tax environment. This still appears to be a good opportunity, though, in the current tax environment, so I expect we'll be seeing a number of general powers of appointment coming our way in the next few years.
Thank you, Tammy and Neil, for teaching us more about powers of appointment.
Thank you for listening to ACTEC Trust and Estate Talk, the podcast about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this station on iTunes, Stitcher, Google Play, or wherever you download your podcasts. And follow us on Facebook and Twitter at ACTEC Talk.